is the case of the State of Ohio versus Jesse Clark, case number 23 CR 40415. Present before the court is Mr. Clark, right?
Yes, sir.
We have Mr. View from the prosecutor's office and Officer Niemeyer from probation. We're here today for a final ILC violation hearing. Mr. Clark, you previously waived your right to be represented by an attorney. If you changed your mind in that regard, we can still get you an attorney to represent you in this hearing. Is that still your choice to go forward without a lawyer?
Yeah, I guess so.
So here's the way we can go, Mr. Clark. We're here today for a final ILC violation hearing. That means that I'm going to hear some testimony about whether or not you violated the terms of your ILC. If you did not violate the terms of your intervention in lieu of conviction, I'm going to release you from jail, put you back on ILC, and you'll follow the rules. If I do find that you have violated the terms of your ILC, then I have to figure out what to do about that, which could include any of the things that we have previously talked about. The maximum penalty in this case is 12 months in prison, plus an optional period of post-release control of up to 2 years. It's not a prison case. There is no set of circumstances today under which I'm going to send you to prison for a violation of your ILC. But I'm going to hear some evidence, and I'm going to figure out what to do next. I haven't heard that evidence yet, so I don't know what it's going to be. I do know that you have 63 days of jail already, and this is not the most serious offense that's come across this court here recently. If you want to admit to the violation and be done with all of this, I will sentence you to 75 days in the county jail, credit you with the 63 days that you have already done. When you walk out of the jail in 12 days, you will be done with everything that you have to do with us. Alternatively, if we have a hearing today, I might hear something that thinks maybe 75 days is too long, and I should release you sooner than that. I'd also hear something, though, that suggests to me that 75 days is not enough in jail, and I might want to do something else. So I just want to make sure that you understand what your position is here.
Yes, sir.
All right, what do you want to do, Mr. Clark?
I'd like to admit.
All right, do you understand the rights you're giving up by admitting to the violation?
Yes, sir.
Do you admit or do you deny that you violated the terms of your ILC?
I admit.
Based upon your admission, I find you have violated the intervention in lieu of conviction. It's my understanding, Mr. Clark, from our last discussion, you want to be done with this, go smoke your marijuana, right? I mean, that's the plan?
Well, I would like to read something.
Sure.
So, good afternoon, Your Honor. First, I'd like to use a minute to apologize for my lack of composure at my last appearance. I had turned myself in at the request of my probation officer Tuesday, March 18th.
Mr. Clark, I usually don't interrupt you in a prepared written statement. You don't need to apologize to me. Things get out of hand sometimes. I'm not holding what happened at the last court hearing against you in any way.
Okay, sir.
Go ahead.
Okay. And when I was right before you the 26th, that made day number 8 that I had gone without any of my prescription medications I've taken for the last 8 months. Several things for antidepressant, mood stabilizers, anxiety, and blood pressure, and antipsychotic. For whatever reason, the county jail failed to produce any of these medications for me, and the sudden deprivation of those medications unfortunately did have some negative effect on my mental health and psyche. Your Honor, I'm sorry, but I felt defeated. I fought extremely hard to overcome an addiction to debatably one of the most addictive substances a person can consume. I voluntarily said I'd like to try the rehab program at Nova, where I went for 30 days after sitting 53 days in the county jail. While arguably better than the county jail posed its own set of conditions and problems, but I made the best out of it and tried to get everything positive out of it I could and remained clean and sober since. Actually 8 months clean as of yesterday. I have participated in significant outpatient alcohol drug treatment as well as mental health appointments and was scheduled to start a new job. I had just left my interview when I got the text from Jessica that I needed to turn myself in over to the jail. Employment has been hard to come by with the lingering charges. Anyways, I contribute my recent success ultimately to my will to want a better life and my faith in God and His Son, Jesus Christ, though I'm humble enough to admit that the physical success I've had over my addiction has also contributed to my medication, methadone, and medical marijuana prescription. Just so you're aware, I did try to refrain from using medical marijuana, but after a panic attack and almost relapsing on fentanyl and thinking all kinds of crazy things, I luckily was able to find relief in my prescription medical cannabis, and I was able to gather myself and carry on with no harm to myself or others. I wish I could wake up and feel great, would not ever have to take anything, that'd be paradise, but unfortunately right now it seems I do have to take these certain medications currently to help me live a healthy and productive life. So I'd like to say thank you to you, Judge Oda, and thank you, Jessica Ruff, with probation for holding me accountable during a time in my life that I was really struggling. And thanks for everything y'all have done that has had a positive effect on my life. And I ask you please take into consideration the opportunity for employment I just received, and that I'm also on felony probation in Butler County and for some period of time. Thank you, Your Honor.
Mr. View, anything from the state?
Just so we're clear, Judge, are we revoking ILC, sentencing him to a local term and then terminating probation, or?
Yes.
Okay. Nothing additional, then, Judge. Thank you.
Officer Niemeyer?
Nothing further, Your Honor.
All right, I am going to, technically, Mr. Clark, you're on community control while you're in the jail, so I'm going to sentence you to 75 days, so for the next 12 days, you're on community control. So if you get in a fight, get caught with drugs, I could still send you to prison for up to the maximum penalty in the case. But just do your time out, be done with this. 75 days of jail, 63 credit, not going to impose a fine. I am going to impose the costs. Do you have a holder anywhere?
Yes, sir.
All right, if you want to go pick up litter with the crew, I will give you an additional day of jail time credit for every day that you spend on the pickup crew. And you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, all those will be provided to you at no charge. I hope that you and I don't see each other anymore, Mr. Clark.
Thank you. I appreciate the litter pickup. If possible, I would like to do that. Sure.
They'll find you. They're short on the crew right now, so they'll probably find you as soon as tomorrow.
All right. Thank you, sir.
All right, that's all. All right, we are waiting on Judge Teep to finish his Back on the record with everybody present, I did have the opportunity to review the evidence and my notes regarding the testimony. There was one clarification. I don't know if the files had audio or not. I did not have my computer turned up, so I don't know if the files that you gave me, Mr. Hardman, do have audio on them or not. If they do, I didn't listen to it and I didn't consider it. So, something Mr. Lewis said in his closing argument caught my attention, and I feel like it warrants some explanation before we get going, and that is that there was a comment that it was the court's role to seek justice. And, I hear this from time to time, where a case might suggest that we want justice for this victim or justice for this defendant. And I do tend to push back on this characterization because I think it focuses on the outcome and not the process. In this proceeding, as in all proceedings, it's incumbent upon this court to follow the law. And in the vast majority of cases, the law leads us to justice. Not justice for the victim, not justice for the defendant, but just justice. And sometimes, though, following the law results in an unjust result. We have a prosecution sometimes neglects an element. We have a defense that sometimes exploits a fine point of law. Sometimes a trial is not a just outcome, but the court is bound by the law, and we follow the law wherever it is that it takes us. That being said, with regard to this particular case, the defendants are each charged identically in separate indictments. Count 1 is attempted murder. Count 2 is felonious assault by causing serious physical harm. Count 3 is felonious assault by using a deadly weapon. The court finds that each of the co-defendants were complicit in the assault on Mr. Vinegar. Tiffany Parks appears to be the ringleader. And Ms. Crooker, I did not bring in my notes. Can you go grab those off my desk? Ms. Parks does appear to be the ringleader of this sort of impromptu posse that was put together. She was mad at Mr. Vinegar for what happened the day before. She was looking for some payback. It's not entirely clear to me, though, how the troops were rallied, if that's even a thing. But it is clear to me that everybody pours out of these cars at this intersection in Mason looking for a fight. There is no other explanation for this behavior. From watching the video, you can see that Derek Floyd, Corey Matthews, Zoe Matthews, D'Amber Mitchell, and Brittany Matthews are all principal offenders. They each engage in the physical altercation. The attacks by Mr. Floyd and Mr. Matthews are particularly brutal, especially near the end of the altercation. Ms. Mitchell appears to be holding Mr. Vinegar down, also strikes him at one point. That may in and of itself be a misdemeanor assault, but when you view it in the context of what everyone was doing, it's just not that way. Brittany Matthews also attempting to kick Mr. Vinegar. It does seem like the pile sort of rolls over on her. Participation of Ms. Parks in the actual assault, it's not on the video, but she is complicit in the crime. She aided, abetted in this beatdown of Mr. Vinegar. The mere presence of her is not enough to establish, as with any of these people, that they were complicit with the principals, but it is within the purview of the court to infer, based upon the circumstances and evidence, that the presence is part of the crime, and I do, in fact, make that inference. So I do find that even though the state has not really established the planning, design, conspiracy aspects of this case, all of the elements of complicity are there. I further find that the defendants were at fault in creating the situation that gave rise to these events. None of them had a belief at the time that they entered Warren County that they were in any imminent danger of death or great bodily harm. Mr. Held testified that the man in the red shirt, that being Mr. Vinegar, was on the defensive. He was being attacked by others. Court finds that Derek Floyd and Corey Matthews were the initial aggressors in the altercation. They exited their vehicle, ran towards Mr. Vinegar. There is no evidence whatsoever that Brittany Matthews acted in self-defense. The notion that these folks followed Mr. Vinegar and a Mason to retrieve some car keys and then a fight starts at his behest, that just doesn't really, it defies common sense. So with regard to the felonious assault part of this case, it's pretty simple. Straightforward. The defendants both individually and collectively engaged in a course of conduct that caused serious physical harm to Mr. Vinegar, and they used two deadly weapons, specifically the baseball bat. Even though not everybody in the group swung a baseball bat or kicked or hit, they are all regarded as equally guilty as if they personally performed each and every one of the acts of this offense. I do find that the state of Ohio has proven all the essential elements beyond a reasonable doubt of felonious assault as to each defendant, either personally or as an accomplice. I'm going to find everybody guilty of counts 2 and counts 3. The attempted murder charge is a little more complicated. The essence of this charge is that these defendants, at least one or more of them, had a specific intent to kill Mr. Vinegar and engaged in conduct which, if successful, would have resulted in his death. Make no mistake, this is one serious beatdown. It's difficult to watch. The state has suggested that I am to infer from the nature of the conduct, the violent nature of the acts, that they intended to kill Mr. Vinegar and only stopped because they thought he was dead or going to die. I'm not going to make that inference, nor do I think that the text from Ms. Parks about killing or looking for him, any of that testimony, I don't think that that shows an intent to kill. Despite the violent nature of the offense, there simply is no evidence that there was either an individual or a group intent to kill. I find each of the defendants not guilty as they are charged in count 1 of attempted murder. I'm going to go ahead and set this matter for sentencing in approximately 30 days. We're going to do level 3 pre-sentence investigations, and we will come back here for sentencing. Does it make sense to try to do get a half day or something and do them all at the same time? That seems to be efficient, right?
I wouldn't disagree, Your Honor.
All right, well, why don't we adjourn to see Ms. Idle?
Your Honor, I'm going to ask that you send this matter to Hamilton County Juvenile Court for disposition. She was bound over from juvenile court here on an attempted murder. Felonious assaults were added here. Those charges in and of itself would not have led to a mandatory bind over, and I'm going to say not even to be bound over at all. So I'm asking that you send us to her home county of Hamilton County for disposition.
Why don't you go ahead and file a motion with regard to that?
Okay.
To be honest with you, I don't do enough bindovers to know what the law is in that area. So,
That's not the process. 2152.121 indicates this court will sentence her with regard to the offense for which she has been convicted. At that point in time, this court will have to make a finding as to whether or not the felonious assault was a mandatory bind-over, possible for bind-over or not. And if she is, and I believe this would not be a mandatory bind-over, so this court, but I think it is possible for it bind-over regardless, so the court will have to send it back to the juvenile court at that point. But it doesn't happen until this court sentences her on the original adult felony under 2152.121.
might be true, I don't know.
Might be true.
All right.
I'll file any appropriate motions.
Yeah, I mean, we'll go ahead and set it for sentencing. That way that gives everybody the chance to figure out what it is. Anything else on behalf of the state?
No, sir.
Anything else on behalf of any of the defendants?
Thank you, Judge O'Donnell.
No, Your Honor.
All right, we'll see everybody back here in about 30 days. Let's take some time to talk to your clients, but make sure that you do not leave until we reconvene with Ms. Idle, who is in her office. All right, that's all.
Can I borrow you for just a quick second? Sure. Your Honor, can we, on a different matter, see you for like 30 seconds? No,
Yeah. Thanks, sir. Nope, I'm good. Thanks for your time.